Hi, everyone. I'm attorney Donna DiMaggio Berger, and this is Take It to the Board, where we speak condo and HOA. Florida certainly has its share of housing for older persons communities, as do other states with large populations of retirees. The pundits say that age is just a number, but if you want to live in a community that excludes children, that number is pretty important. My guest today is my partner at the Becker law firm, Mark Friedman, who has represented a number of large 55 and over communities over the years. Mark is a board-certified specialist in condominium and planned development law. He teaches numerous seminars and presentations at our firm's West Palm Beach office, as well as to community and civic organizations. He was ranked first in his law school graduating class, was the senior editor of the Law Review, and was the first place winner of his law school's moot court competition. So he's a classic overachiever. Mark and I are going to be discussing today the legal requirements to establish a community as housing for older persons and whether these communities have the same appeal today as they did in the past. After all, living in one of these communities is an admission that you've reached a certain age, and ageism is alive and well in our society, so this should be a very interesting conversation. Mark, welcome to Take It to the Board.
Hi, Donna. Thanks for having me. I will say this, that in 2022, I got my first senior discount and my first pair of orthopedic shoes. Literally, I'm not even making a joke. So I am sort of feeling that age is kind of creeping up on me. And as you said, I do represent a lot of different communities. I have about 120 Century Village communities, which are housing for older persons up here in West Palm Beach that I've represented for a number of years.
Well, let me start out by saying that when I look at a picture of my grandmother when she was 45, she very much looked like a grandmother. And just for our listeners, I want to compare and contrast that to the fact that Jennifer Lopez is 53 years old today. She's actually going to be 54, I believe, in the summer. So she's a year and a half away from living in one of these communities or being eligible. And Halle Berry, another well-known actress, she could have been living in one of your communities, Mark, for the last 2 years. So let's just let that sink in for a second.
And I've noticed that too, even with my own mother, who's in her 80s, and she doesn't look like what I remember growing up of people in their 80s. You know, she's very spry. She keeps herself put together. The hair is still colored, so it's brown. So she looks like maybe somebody in their 60s. And I've noticed that kind of trend. Maybe it's the health trend. Maybe it's the internet and people trying to stay young and fit. But no matter what they look like, whether they look spry or they look elderly, the same rules are going to apply to all of them. And, you know, that's what sometimes they don't understand when we have to deal with the issues surrounding these communities.
So let's talk about the basics. What is legally required to establish a community as housing for older persons in order for that community to deny families with children from living there?
So there's really three main criteria. The first is that your governing documents, the declaration of condominium in a condominium, or the declaration of covenants and restrictions in an HOA, or the various documents in a cooperative, have to say that you are intending this to be a housing for older persons community. And then at least 80% of the occupied units must be occupied by at least one person who is 55 years of age or older. And the community has to comply with HUD restrictions for verification on occupancy through various reliable surveys and affidavits. So if you have those three criteria, you can be a housing for older persons community and maintain that status.
A lot of these large communities that I know you represent, Mark, and that I represent, they have a lot of committees. They've got the, activities. They've got amenities. Is that necessary to qualify? I know it wasn't exactly what you said as one of the three-pronged tests.
It used to be back in the late 80s. You had to have facilities specifically designed for the elderly residents. But when the Housing for Older Persons Act was signed by President Clinton, it removed that as a specific criteria. So it's not to say that they don't have it or can't have it. It's just to say that that no longer becomes a criteria for whether you are or aren't such a community.
Can you tell us what the magic words are? I know in some older documents, it'll say things like no children younger than 16. And I know that doesn't meet the legal requirements for the language establishing a community as a 55 and over. And again, I should have started out at the outset. Mark is here and he's blessing us with his wisdom, but he is not providing specific legal advice for your community. But that being said, from a general standpoint, what's the magic cutoff? It's 18, isn't it, Mark?
Right. So the first of your two questions was, what are magic words? Well, there's actually magic words that don't lend yourself to being a housing for older persons community. For example, you can't just say we're an adult community. That doesn't qualify as housing for older persons. So there's actually a statute because for some reason, older documents used to use 16 as a cutoff. So in Chapter 760 of the Florida statute, it says something to the effect that if your documents say no one under 16, it will be taken to mean no one under 18 years of age because 18 years of age is the age of majority in the state of Florida. And another, I don't know if this podcast is heard outside of the state of Florida, but everything we're discussing, fine print, has only to do with Florida law, not the law of any other state or area.
Mark, this podcast is heard on 6 continents.
There you go.
Well outside just the state of Florida. I'm sorry, go ahead.
Yeah, so it is 18 and under. One of the interesting things that I find in a lot of the older documents in Century Village is that because the statute specifically had a 16-year age cutoff, whoever was drafting the documents back then, which is like 40, 50 years ago, whenever they were created, they actually used the cutoff age as 15, so it fell outside of what the statute was talking about of age 16 and under. So we end up with a bit of a conundrum because their documents will say no one under 15 years of age can stay in the community. So I asked them, well, what happens if a 16 or 17-year-old wants to move in there? So we obviously recommend that they amend their governing documents to meet current legal criteria so that there aren't these legal conundrums created by what was probably once considered clever drafting.
Well, let me follow up on the amendment. So let's say that a community was never intended by the developer to be housing for older persons. But over the decades, they've now gotten to the point where there are a sufficient number, more than 80% of the units are occupied by someone age 55 and over, and they don't have anyone younger than 18 living as a full-time resident. Could that community simply now create an amendment to turn themselves into housing for older persons?
So I've never done that. I've never had a community actually request that. But if they're hitting the 3 main criteria, I believe that they could, the 3 criteria we previously spoke of. But that's obviously something that would really require a little bit more research because you're literally changing the dynamic of the community from one that allows everybody to one that doesn't. So if you had even one unit that wasn't there, they probably have to be grandfathered in. There's a lot that would go into that kind of a shift in the dynamic of the community.
And certainly not an amendment or a shift that a board should undertake without the benefit of experienced legal counsel.
No, and the problem is that most of the boards, even in housing for older persons communities, don't even do the basics sometimes, that they shouldn't undertake anything of that kind of a major shift. One of the things that if anybody who's in one of those communities and is listening to the podcast in any of the major continents that you've referred to,
not Antarctica. Nobody in Antarctica.
No, nobody in Antarctica, but maybe the Arctic Circle. The thing that is most important is that they take their survey every 2 years. This survey, which is like a census, you have to go around and make sure that people haven't died, moved out, changed, so that if there's an issue where somebody moves in who brings a young child, an infant, a toddler, somebody under 18, and then you want to have your attorney try to go to court to remove that person if they don't do it after a demand letter, if you haven't done your census or your survey every 2 years and have an up-to-date one, well, we can't go to court at that point to assist you with the issue. So it's very, very important that if you haven't done a survey or a census within the last 2 years, and it hasn't been done that way, that you contact your attorney because that will determine what you can and can't do legally when an issue arises.
What kind of identification is needed when you're conducting that survey, Mark?
So it's something that will show your age, like a birth certificate, a driver's license, a Medicare card, voter's registration, military identification cards are also allowed. Anything that's from a local or state government or a government of another nation, as long as it can show verification of age. Obviously, people sometimes try to show ID cards that don't have their birth date on it or don't show the age. That wouldn't apply. Now, the law also says that it takes into account that some people don't want to play and don't want to show you these things. And if people refuse to cooperate, then the board, through an affidavit of their personal knowledge or other information they may have in their files, such as their identifying information with their application when they moved in, the board could, through affidavit at that point, sign something to say that they are verifying that at least one of the occupants is 55 years of age or older. But that's just the last resort.
Does the board take an actual picture of these ID cards and keep them, or do they just have the person who saw it fill out an affidavit saying, I saw this piece of age identification for this unit? What's the preferred methodology?
I would prefer the latter, where somebody who saw it just fills in something as an affidavit, a document. But when we create the affidavit documents for our clients, we'll oftentimes say in there that so-and-so has provided the following, a photograph or photocopy of the following document and is attaching it to it. And the reason we do that is because, at least in the area that I work, which is the Palm Beach office of Becker, where I've been for almost 18 years now, it's a very snowbird type community. So if you don't actually catch a survey when everybody's in town, sometimes the buildings are just empty and there is no local person who could verify it. So we'll have them send that in. Now, my concern with that is the security over those documents.
Right.
Because, for example, in a lot of the Century Village condos, there's no office. There's a laundry room, maybe a storage room, and a lot of these documents are kept in a locker that's in a laundry room, or they're kept in a board member's unit. And for example, I have a board member who's gravely ill, and her family found a box of documents and called me. Fortunately, my number was in there to say, what do we do with these documents? Because to her, it didn't look like much because it wasn't neatly filed. It looked like, was this trash or was this association documents? So I explained to her what she needed to do with them, give it to another board member or bring it to our office. But the security of these documents is very important in this day and age when identity theft is rampant, because you never want to have identity theft traced back to an association because you collected this information because the law requires you to do it, but then you didn't put it under lock and key.
You mentioned that the best practices is updating the survey every 2 years. So I suppose what that means then is shred the old documentation, correct?
Well, no. So I was looking at some HUD guidelines, and the HUD basically says you're supposed to keep the surveys. I think it said for as long as you want to maintain your status as housing for older persons. And then the Condominium Act also has a lot of rules and requirements about how long you're supposed to keep documents. So you wouldn't be shredding documents every 2 years. So that's definitely not what they should be doing, but they definitely should lock and key, digitize them in a way that they can't be found by persons trying to hack computers. I mean, this has always been a big issue because a lot of seniors, my parents, for example, they're in their 80s, just like a lot of people in some of these communities. My mom uses a computer for email and Facebook only, and my dad has never touched a computer in his life. So when you're getting these types of documents, a lot of very senior people don't know enough about computer security and how to operate computers to secure them digitally. So they rely on the old sort of file cabinet with a key. And we all know that's as safe as the person with the crowbar and how skilled they are,
I'm thinking of my parents too, although mine are equally impossible when it comes to technology, although they are excellent with their shredding machine, which may be why I asked the question about shredding every 2 years. Every time I go over there, I find my parents shredding something.
It's a hobby.
It's actually not a negative hobby. There's worse hobbies I could think of. But let me go back, because I asked you at the outset if there was a community that wasn't originally designed to become housing for older persons. Conversely, occasionally I have a client where they were set up originally as housing for older persons. And over the years, they've moved away from that model. They don't meet the 80% threshold of having at least one unit occupied by somebody 55 and over. And they no longer really want to hold themselves out, nor can they legally hold themselves out as housing for older persons. I had a client once say, well, we just don't enforce it. But that is a problem, still having those age restrictions on the books in the public records without amending it, correct?
Yeah, because HUD doesn't like to see things in writing that aren't true, especially because in a housing for older persons community, one of the things that is your benefit is that you cannot be found liable for familial status discrimination, meaning discrimination against parents with children under 18. So if you're saying we're a housing for older persons community in your documents, you might also, because you used to be, have a lot of rules that are specifically targeting children. And now you're no longer a housing for older persons community, and all of those rules no longer have the protection of the federal and state laws that say you can't be liable for familial status discrimination. So now suddenly you're left exposed, when you have all these rules. And so if this is where your community is headed, or if you've fallen out of the 80-20 dynamic, you definitely need to amend your documents, especially your rules and regulations, because even communities that are not housing for older persons, when I read the rules and regulations that talk about children, it kind of puts a knot in my stomach because I know what the criteria for HUD would be. So if you've accidentally or intentionally allowed your community to slip out of that, immediately take care of your governing documents to avoid a problem.
Because a potential purchaser could maybe never speak to the board or the manager and inquire about whether or not the community still is housing for older persons. But just by virtue of looking at those antiquated rules, or the provisions, the age restrictions in the governing documents, that alone may dissuade them from even applying to purchase or to lease there when the place no longer can prohibit younger occupants or families with children. So I'm right there with you in terms of telling my clients, look, if you're under the threshold, then you need to amend the documents so it's clear, even to just a potential purchaser or a potential tenant, that you are no longer restricting ages in the community.
And if you're not a housing for older persons community and you've drafted your rules yourself, see your community association attorney, whoever he or she is, because the reality is you're probably put in criteria that only belongs in housing for older persons community rules, and that alone could get you in trouble.
The timing of this episode with you, Mark, is perfect because I just had this come up in one of my communities, and it's come up a lot before in my age-restricted communities. We've got an applicant for purchase who is underage. It's an adult son. He's only 51. His wife is 50. And they're applying to purchase a unit in a 55 and over community, but they're claiming that his mother will be living there with them. Now, the board doesn't believe that this is really going to be the case. How do you counsel clients when that scenario presents itself, where somebody younger is purchasing, but they're claiming either they won't occupy the unit until at least one of them becomes 55 or older, or they're claiming that somebody older is going to live with them?
So first thing that's very important for everyone to understand, as you well know, the housing for older persons restrictions is an occupancy restriction, not an ownership restriction. So at first blush, we have to be very, very careful, because if we are going to say no for some reason, it cannot be or appear to be based on anybody's age, because at least in Palm Beach County, Broward, and Miami-Dade, age is a protected class under county ordinance. It's not in some of the other counties on the west coast of Florida. But if age is a protected class and you deny them the ability to purchase based on the fact that they're not 55, I had that happen in one community, filed a HUD complaint, and it took 2 years before the matter was resolved because they couldn't say no just because he wasn't. Now, are they going to follow the requirements of your documents? So at least their stated purpose is that we are going to have somebody 55 years of age or older living with us in the home. What I like to do, and I'll amend this into documents as well, is I like to have that person sign an affidavit saying that they know that this is a housing for older persons community and that they will follow the occupancy criteria of the federal and state laws and of the governing documents, and at least one person occupying this unit will be 55 years of age or older, and that they will not violate such occupancy criteria even through their own residency of the unit. That's at least how I like to frame it. In other words, we're not going to say no, but we just want you to verify that you understand what type of community you're moving into along with your mom, or that your mom is moving into, and then we will definitely sell this to you. Just sign this piece of paper for verification. I don't know if this was a ruse and they moved in without their mom, if a court would just look at that affidavit and have them remove themselves from the home that they own or the condominium unit that they own, but at least it's something. It puts them on notice that we're watching, that they're signing something that says that they understand that this is a housing for older persons community. And it's a piece of paper that they know if they're playing a game that we might use against them. So maybe they're less likely to want to violate that which they have just signed.
And for the people out there that, let's say, are the more honest citizens, yes, having to sign an affidavit that then requires a notary, that may give them pause. But we both know that there are people out there who will randomly sign affidavits and then turn around and do the exact thing they said they wouldn't do. To your point, I ask for the same thing, Mark, and I say the same thing to a client. Look, this affidavit is certainly not a silver bullet, okay? But at least it's an indicator to the court if we have to move forward on the violation, that there was a fraudulent intent here. So I agree with you on that.
When you do these types of things, clients have to be aware that, nothing is going to be a perfect answer. There are always going to be those people who are going to try to play you by telling you. I have a lot of times, with 120 small condominiums, I constantly have these types of requests for, third parties that aren't going to be named on the deed or moving into the home. And most of the time, it turns out that that's exactly what happens. So you have to be very careful. What I always tell clients is when you get an application, if you're going to say yes, you really don't need to call me because generally that won't go south. But if you ever even have the slightest inkling that you're going to say no, call me. Let's talk about it. Let's make sure that you have the legal authority to say no. And if you do have the legal authority, are you saying no for the right reasons? And what are the potential ramifications?
You said earlier that this is really tied, safeguarding the housing for older persons status is really tied to occupancy. It's who's living in it. So let's talk a little bit about who's living in it. What's the cutoff for underage occupants? In a lot of these communities, it doesn't mean that the residents, that the people living there don't like younger people and they never want to see them. They're grandparents. They want to see their grandchildren. They want to have them come visit for the holidays. But at what point does a younger person occupying the unit now tip the scales in the other direction?
So there's not really so much of a cutoff. I think the HUD regulations talk to the fact that you want to show that you're trying to maintain a community for older persons. So you would never have something in your documents or have an allowance that say somebody under 18 could live there throughout the year, because that would not show that you were trying to maintain the status that you have for this type of community. Your governing documents should have very specific guest restrictions. I have some odd guest restrictions in some communities where it only speaks to children under a certain age can stay for so many days, but it doesn't cover, people who are from 18 to 54. But if you have your guest restrictions set up, that's where you really have your criteria. If you allow too much latitude, somebody might argue that you're not really housing for older persons anymore because you just allow any child to live there or stay there or visit indefinitely.
But you kind of just touched on my next question, which is, you have that 20% cushion, right? The law is at least 80%. I know a lot of communities you represent and I represent, we counsel them to go for the 100% mark. But what do you tell your clients about the use of that 20% cushion?
Well, usually once a year, I will do some kind of seminar that touches on this. And the question always comes up, is what about the 80-20 rule? The realtor told me about this 80-20 rule.
It is a realtor normally who
usually
will say,
is. And look, I have about 3 realtors in my family, so I'm not casting aspersions on realtors. But usually they were told by a realtor that there's an 80-20 rule and you have to allow in the 20% this particular individual who I'm bringing to you. So there is no 80-20 rule per se where it's like 20% must be this or that. HUD says they don't care what you do with the 20%, but they do say that you must be very careful with it. Because, like, for example, I'm 61, my wife was 51. If we both lived in such a community and something happened to me, she's 51, she doesn't meet the age criteria. So the 20% was made for that type of a scenario when you look at the HUD question and answer sheets. So they say that we're not going to tell you what you have to do with the 20%. But make sure you calculate things well so that when you have this type of scenario, you don't all of a sudden lose your status, because you don't want to have this situation where you have to ask the widow to leave. And then if she fights back, a judge might just look at you like as an association like you're crazy. He may just say, I'm not going to make her move out of her house that she's lived in for 20 years with her now deceased husband. I'm going to basically say you're no longer housing for older persons because you were sloppy in how you handled your 20%. So the 20% criteria should always sort of be safeguarded for those situations where you didn't have control of the situation. There was a divorce, there was a death, there was somebody who ended up at a nursing home and the younger spouse continues to reside in the home. You shouldn't just be allowing those to be sold off because, if you have a building where there's 20 units, we're talking 4 units before you're out of your 80-20. So, we get these types of questions every year about this 80-20 rule, and it doesn't exist as a rule that you have to do something specific. So you're right. I do tell the clients they should think of the housing for older persons. It should be when we're screening the occupants, we're looking for 100% of units where it is at least one person 55 years of age or older. Something happens, tragic or whatever, over the course of their time in that unit, well, then they'll fall into the 20%. And then that's where we'll pick up the 20%.
I agree wholeheartedly with you. The other thing we haven't talked about is adult children who inherit the units. So I've got a few 55 and over communities where they have no leasing. But the problem has arisen when the parents pass away and you've got children in their, let's say, early, mid, and late 40s who inherit this unit. They can't move in, and they also can't lease. I guess at that point, they are forced to sell because for some of them, the math doesn't add up for them to hold on to the property and continue paying maintenance and everything else, waiting a decade or more to be able to move in, particularly if they can't lease.
Well, that's why when I do no leasing restrictions, I oftentimes ask the boards to think about that exact criteria, because sometimes a carve out, even if you allow leasing for 1 year, I would rather have the person who has received the gift from their deceased parents sell the unit for a really good price, which will keep up the values of the units in the condo, rather than just walk away from it. And then you have to have a lot of procedures with, foreclosure to get title to the unit. So I often suggest a carve out on the leasing, if there's a no leasing restriction, to at least give them one time for 1 year to lease it, to figure out what they want to do with the unit so that they can either sell it or make a determination, like maybe they're 53, and if they can lease it once and then maybe have it vacant for a year, they can maybe move into it or use it as a vacation place. I have a lot of people that come to the Century Village. They're very wealthy, but even though these units are very small and some of them are sell for $80,000, they're not very big, just because of the close proximity to the water here in Palm Beach County. So, maybe they'll use it as a second home or criteria if the age can be met. So sometimes it's just not the one section of the documents that I look at, but kind of globally as to how can we make this work? Because for the association to have to go through a whole foreclosure process to take a unit owner from beneficiaries or heirs that don't want anything to do with you is more problematic than allowing one lease.
So I want to talk about a sticky situation.
How sticky is it?
It's going to be sticky. So it's a unit that's in compliance. But let's say we have a 58-year-old man. Well, we could even use your situation. 61-year-old man, 51-year-old spouse. She gets pregnant. What do we do? By the way, I know you have toddler twins, and we're going to talk about that later. But do we have to move these people out?
So the reality of this situation is, this is a housing for older persons community. It didn't become housing for older persons while they were there. In the 80s, that might have been an issue. More likely than not these days, you knew what you were moving into. And the association would have to make a determination. Is this somebody we're going to allow into the 20%? Or is our 20% kind of bottled up because we only have 4 units and 3 of them are already taken up that we can't allow this to happen? So those are the 2 options. You could, in essence, like my sister lives in a huge housing for older persons community in Orlando. I think there's like 500 homes. Do the math, since I can't do it in my head very quickly. What's 20% of 500, right? So you might, depending on the community, allow them to be part of the 20%. Or you could say, look, no, we reserve 100% for this. You knew what you were getting into. We're going to go to court and ask the court to have you sell your house and move out.
But the language I see, Mark, is even with the 20% is every unit must be occupied by somebody age 55 and over, but in no event may children younger than 18 reside in the community. So how does that, now you've got children growing up, babies and toddlers, that fits within the 20%?
You'd have to look at the specific governing documents, because in older communities, especially those that were created right when the housing for older persons laws first came into vogue, the language is really very sloppy. So I don't know if it's even 100% that clear. So you're right. If it specifically prohibited children at all, then you might have to force them to leave. And you have to say, look, your residency now is out of compliance. Again, judges are human beings. There was a case in Palm Beach County, I want to say it was like 10 years ago, where there was a granddaughter who was living with the grandparents, and of course the community wanted her out. But it was something where either the parents had died or they were in prison or something, where this was the only family left to this child. And the elderly people, they weren't wealthy. They couldn't just pick up and leave. So the court basically took a very humanistic approach, ignored the law, and said, we're going to let her stay in the condominium. I don't know if you remember that case.
I do remember that case. And there was another case where grandparents had a grandchild living with them, and they claimed that the grandchild was needed as an accommodation to help them with their medicine and their care. And I've seen those cases.
So there's a lot that goes into this type of scenario. A lot of it's fact-based, a lot of it's emotionally charged. And again, like I said, judges are human beings. These cases were never appealed. So who knows if the appellate court would have looked at it strictly construing the law and told her that she had to be out of there. It's really very hard to say.
It does require a humanistic approach, although you would think that if it's the only child in a community with 500 homes, that, they would think, well, we probably want to be living somewhere where this child will have other kids in the neighborhood to socialize with. But to your point, a lot of these communities are very well maintained, and they're still very reasonable in terms of pricing. So I understand it from that point as well.
When I visit Century Village, I see a lot of kids walking through there, like after school hours, as if they're coming from a bus stop. And sometimes I'll say, like, where are they going? We're in a gated community of 309 senior condos, and there's like 10 kids that are walking back to like they're going home or something after school. So I know it occurs. I think that sometimes they keep it on the down low just so that
I was going to say, maybe you're witnessing violations.
I may be witnessing violations or boards that have turned blind eyes. I have no idea. But to your point about the question, yes, it occurs. And I guess either their documents weren't well written enough or they turned a blind eye or something.
When I said in my introduction that being 55 today is not nearly what it was decades ago. I know people in their 55 and their mid-50s who have toddlers, who have young children. Shouldn't we really change this threshold to 65 and over, even if just for marketing purposes?
Well, let's see. When I'm 65, my kids will be about 6 years old. So I'm not sure how personally, that's going to help. Actually, the state law in Chapter 760, it does speak that you can have a community of, I think it says those who are only 62, not just one person who's 62, but you could have a community that is of persons who are just 62 years of age. I've never seen any community that I've represented that's done it that way. I mean, legally, it can be. HUD allows you to raise the age threshold, but says be careful of local ordinances based on age protection. So because at least in South Florida, we have age protections, I don't really think you can do that without a change in the federal and or state laws, with the age thresholds being what they are, so you don't run afoul of local ordinances. And again, if people are having kids later, you have 18 years technically. So I guess if they're 50 when they have their kids, it'll be 70. And for me, I'll be somewhere in my 80s before I can move into a housing for older persons community. So,
Mark, you're going to be that older parent dropping the kids off at college.
I know. That's why I try, notwithstanding the orthopedic shoes, to keep myself in good shape so that people don't think I'm the grandfather, that I'm the father. That's why I always wear my dad hat, so that people know that I'm dad and not grandpa.
You look great. They're never going to mistake you for grandpa. But let me ask you this. I don't see that many new, large 55 and over communities being built these days.
Well, you haven't come to Boynton Beach because there's a huge Valencia going up where the prices start at $900,000 and it's probably 500 homes.
And it is a 55 and over community.
All the Valencias, to my knowledge, Valencia Lake Shores and others, we've represented a few of them from time to time. They've all been senior communities. I know my sister lives in a mega community, kind of like Tradition, that type of style of community up in Orlando, where there's like different sub-communities within it. You got to remember also that at least where we practice, a lot of the areas are built out. So, they don't have the space for another Century Village style complex for the most part. But I mean, when I see these things, even my wife comments is like, wow, I guess that people retired wealthy if you're 55 and over and it starts at the 900. So I think what's happening is that the newer developments are more upscale. They're not the little tiny Century Village condominiums where, it's maybe 800 square feet or 900 square feet of a condo, but it's a full large size house.
You see the appeal is still there for people when they hit a certain point in midlife to say, we want to move into a community where there's not kids running around.
And I think you got to remember, too, there's a lot of people coming down in our area, because what you say may be true for other areas of the country. But in our area, we're getting a lot of people moving in from California and from New York. I mean, I see it now. My wife and I, we're going to the VPKs to take a look around, and sometimes they do cutesy things like, let's everybody say where they're from. And it's like, New York, California. It's like, all the new competition. But also the seniors are moving out of those areas as well down here. So there has to be more housing. And that's probably why it's not flatlining and that they can actually create a Valencia community where it says, starting at $900,000. I mean, I look at that, anything starting at $900,000, it's kind of like, wow, I hope when I retire, I'll be able to afford something like that. Not that I'll be retiring for like another 20 years, but you know what I mean?
Never say never. It's funny. I was thinking about the fact that in some of the communities, we haven't seen the value of the units, the smaller units in 55 and over, accelerate as rapidly as some of the other properties down here in Florida. You're right. Florida's a hot ticket right now.
Because Florida's a hot ticket, while the values may not go up as much as other communities, I have seen senior communities in the area in West Palm anyway, because remember, West Palm's kind of more of the expensive county in Florida. But I have seen where people have purchased for $100,000 and say 5 or 6 years later, they're selling it for $250,000. So, maybe it's not selling for $500,000, but the value has at least doubled during, within a 10-year time frame. Again, I think it's supply and demand. And until things start leveling off with people coming from other parts of the country to South Florida to escape whatever it is they're escaping from those areas, it will increase because there is only so much supply to meet that demand.
And conversely, during our recessionary periods, our older communities seem to weather the recession a lot better. Well, I always thought it was for two reasons. One, because you don't have nearly as many investor purchasers in these housing for older persons communities. And secondly, I always attributed it to the fact that seniors have just more wisdom and they knew how to budget and they could weather the recession better.
I agree with you, at least in part, because they are on fixed incomes in a lot of these communities, not the $900,000 starting price ones, but in the other communities, they're on fixed incomes. I know, and when they call me, sometimes they want to know if I'm billing them for the call. They're very fiscally conservative. I love when they ask me the questions about what the billing is, but they're very conservative, sometimes to the penny. And if you are like that in your community, when hard times hit, you haven't spent all your money. You haven't spent out all the funds that you have. So when they do have a legal need, for example, because we could see it from when they call or if they stop calling, that type of thing. So from our perspective as a law firm, they'll still call when a legal need arises, even during a recession, because they have been fiscally conservative with their dollars. I mean, I do, again, in West Palm, I don't know about as much in Broward where you're located. I see the communities try to stave off the investor buyers because they don't want the renters in their buildings. So they try to make it more difficult through amendments to their documents for the investors to come in, because there's a lot of people from South America, Canada, come in all cash and they'll buy these units. And I think that type of thing also helps. If there's a recession, you have these types of owners in there as well.
So, Mark, you had a whole other life before you became an attorney. And I always think that having a career before you embark on a legal career makes a more well-rounded attorney. And I say this having been a 23-year-old attorney and going straight from 3 years of college into law school. But you have a pretty interesting background. You lived in Japan for several years. Tell me about what you did there and your career there.
So, yeah, being an attorney to me is sort of the midlife crisis type of thing. I became an attorney in my early 40s. So I've been practicing now, even though I'm 61, I've been practicing, 18 years, all of them at Becker. I've been sitting in my same chair here literally for 18 years. I think it needs new padding. So yeah, I was part of the Japan Exchange and Teaching Program back in the late 80s. I was part of the original JET program, and I was fortunate enough to be assigned a school in the deep country. So from my house to the train station was just about a mile of rice fields. Rode my bicycle to and from the school that I was teaching in. It was very dense in Japanese culture and wisdom. And, I learned a lot from those days living in another country and seeing how that country saw our country, getting to see it from the other person's perspective. I mean, keeping to our topic for today, when it comes to their seniors, at least back in the late 80s and early 90s. I mean, I can't speak for now because I haven't been back in a long while. But back then when I lived there, if you had an elderly person in your family, they lived with you. The family took care of their person. A lot of times what we see happening in some of these communities, especially the ones where people are on fixed incomes, is sometimes they'll house them in a condominium where they really should have been spending a little more and putting them in an assisted living facility. In Japan, you didn't see that. It was very family oriented, not sort of like, well, grandma's done with her useful years. She doesn't even remember me. Let's just put her in such and such condominium association and say, see it to the board when, the dementia kicks in and she can no longer take care of herself. So, this is one of the issues that I see as a practitioner, and it's a very difficult one because our social service system in Florida isn't really geared to having a condominium board call a state agency and having them really do anything.
One of the toughest issues ever, I agree with you, is aging in place. People who moved into a condo unit in their 50s and 60s, they're now in their 80s or 90s. They're experiencing cognitive decline. And then, the board will reach out and say, Mrs. So-and-so is, setting little fires on the catwalk or wandering around undressed or whatever it is, and you say, do you have any emergency contacts, family members? Some of them don't have any of those contacts. And even when they do, when you reach out to the adult child who inevitably lives in another state or even out of the country, the answer is, well, it's not really our problem. And yeah, I agree with you. The way other cultures have treated intergenerational living and the way they address care for senior members of their families, it's a model to emulate.
Well, I hope my boys will, because by the time they're in their 20s, I'll be in my 80s pushing 90. So
this may be a self-serving segment. No, I'm joking. Actually, I have to say, I want to thank you so much for your time today, Mark, because again, there are so many of these communities, not just in Florida, but as I said at the outset, everywhere. California, Texas, Arizona, Nevada, all of the states where we see a lot of retirees, because actually a lot of retirees are leaving Florida because of the high cost here now associated with insurance.
And I'm sure they have them in all the other continents you say your podcast is heard in too. They have senior communities.
Mark, I'm sensing that you don't understand that we are on 6 continents. I didn't say how many people in those 6 continents, but I get the report. Anyhow, I want to thank you so much for joining us today. It's been a real pleasure.
Thanks for having me.
Thank you for joining us today. Don't forget to follow and rate us on your favorite podcast platform or visit takeittotheboard.com for more ways to connect.